Parents are the first and most important caregivers, protectors, and educators of their children. Long before a child enters the classroom, parents nurture their development, guide their values, and help them grow into responsible adults. Our laws and Supreme Court precedent have long reflected the fundamental right of parents to direct the upbringing and education of their children. Yet today, that foundational relationship is being increasingly undermined in America's public schools, where some districts disregard federal law and push parents out of the equation. Two federal statutes, the Family Educational Rights and Privacy Act and the Protection of Pupil Rights Amendment, were passed 50 years ago to ensure transparency and reinforce the role of parents in education. FERPA gives parents full access to their child's educational records, while PPRA ensures that parents can review instructional materials and shield their children from intrusive surveys and evaluations. At their core, both laws recognize that parents cannot effectively guide and protect their children unless they have accurate information and are fully involved in their child's education. But in recent years, a wave of secret transition policies has swept the nation. As we heard, these policies are found in over 1,000 school districts. They direct staff to conceal information from parents if a child expresses an identity of a different gender, such as using a different name or pronoun. These policies not only violate FERPA and PPRA, they deliberately sever the relationship between parents and children at moments when young people may be experiencing profound emotional and psychological distress. These harms are not theoretical. At Alliance Defending Freedom, we represent families harmed by these unlawful policies. A Michigan school district treated a middle school girl as a boy, then scrubbed the child's education records before sharing them with her parents. In New York, a mother who noticed that her daughter was struggling with depression and anxiety reached out to school officials asking if they noticed anything about their daughter's emotional struggles. The school assured the mother nothing was happening, yet it was concealing that it had been treating the young girl as a boy for months. That mother's case was argued at the Second Circuit Court of Appeals yesterday. As FERPA's bipartisan sponsors explained, parents need access to such information in order to protect the interest of their child. But when school officials defy federal law by hiding information in shadow records or by conducting informal psychological evaluations of a child without a parent's notice or consent, parents are denied the information and involvement needed to determine what support their child may need. And that jeopardizes children's well-being. Congress must treat these violations with the seriousness they deserve. Safeguarding parental rights by guaranteeing full transparency and involvement for parents is not a partisan issue. It's a matter of moral responsibility and constitutional principle. Thank you.